Right now, we are keeping a close eye on the United States Supreme Court. The justices are expected to hand down a decision on a criminal case that could impact the trial of a Cape Coral boy accused of threatening violence at a school event. That opinion is expected before the 9 justices go into recess at the end of June or early July. I'm Belinda Post in for Nicole Gabe.
And I'm Russ McCaskey. Now that would be just days before Daniel Marquez goes back to court. As we've been reporting for the past year, Daniel sent private text to a friend. Text that he described as a joke about a scam involving money and guns, followed by a reference to a school event. Now, Sheriff Carmine Marcino said he, quote, felt that the 10-year-old was really texting a school threat. Well, Daniel was locked up and charged with a second-degree felony. Week News investigative reporter Celine MacArthur has been leading our exclusive coverage of this story, and she explains how that case before the Supreme Court could impact how law enforcement and prosecutors do their jobs in Lee County.
The case the United States Supreme Court is weighing in on right now is Counterman v. Colorado. In short, this man was sent to prison in 2017 for stalking this woman through Facebook Messenger for years. The two had never met. Everything he communicated was through social media. The woman said those messages scared her. Well, Billy Ray Counterman said he didn't intend to threaten her and was exercising free speech. Well, the circumstances are much different than 10-year-old Daniel Marquez and the joke he said he texted his 10-year-old friend last May. But both cases deal with an issue the High Court deemed worthy of hearing. Can a true threat be words void of intent?
Criminalizing misunderstanding is especially dangerous in an age when so much communication occurs on social media, which brings together strangers in an environment that removes much of the context that gives words meaning.
The speaker's intent should be part of the presentation the jury gets, because that's part of the circumstances. But here, the court and the prosecutor argued that the intent was irrelevant, that he couldn't present any evidence about his intent, correct?
That is precisely correct. They said it doesn't matter what he thinks.
In Colorado, what matters is if a, quote, reasonable person viewed those messages as threats. Under Florida Statute 83610, written or electronic threats to kill, do bodily injury, or conduct a mass shooting or act of terrorism, it matters what, quote, another person views as a threat. During the oral arguments, Justices Amy Coney Barrett and Neil Gorsuch questioned those standards.
Who is the reasonable person?
We live in a world in which people are sensitive and maybe increasingly sensitive. What do we do in a world in which reasonable people may deem things harmful, hurtful, threatening, and we're going to hold people liable willy-nilly for that?
University of Florida Levin College of Law professor Larissa Lidsky explains words also have different contexts among children, like Daniel and his friend.
How do children interpret these things? It's not even a teenager. It's a 10-year-old, which to me is a different standard than you might have for a 16-year-old who might understand how it could be misconstrued in the light of our current social context.
Daniel, who was 10 at the time, explained to the Lee County Sheriff's Office his words were a private joke. In a sworn deposition obtained exclusively by Wink News, Deputy Tyler McArith admit he arrested Daniel because of the content of the texts alone.
It was the fact that there was pictures of firearms and then a quick reply of saying, get ready for water day, putting those two closely together in that context made me believe there's a threat there.
When you then interviewed Daniel, did he say orally to you that he was going to shoot anybody at the school on water day?
No.
When he spoke to you orally, did he ever say he was going to commit an act of violence on water day?
No.
Have you spoken to any officials at Daniel's either current or any other schools that he attends?
No.
Is there a reason why you didn't speak to any officials there?
I didn't think it had bearing on whether he sent the messages that violated statute.
LCSO won't talk to us about the case. Harvard Law professor emeritus and civil rights attorney Alan Dershowitz argues the accused should also have some knowledge that what they're doing, or in Daniel's case, what they're texting, is a crime in order to be convicted.
The essence of tyranny is prosecuting people who didn't know, weren't given fair warning as to what their crime actually would be.
Ken Paulson is the director of the Free Speech Center at Middle Tennessee State University. He wrote a guest column about Daniel Marquez's arrest for an online news outlet last summer.
And just on the face of it, it's outrageous.
And if a child's future wasn't at stake, Paulson's analysis of the texts would be comical.
So you've got your first text in which he explains that he has scammed a friend and made $1 trillion. Well, that's a significant amount of money if you're 10. So what could law enforcement have done with that? He engaged in trillions of dollars worth of fraud. So clearly, let's get a grand jury. Well, obviously they didn't do that. Then you move to the next text, knowing full well that he never really secured trillions of dollars. And he says he used those trillions of dollars to buy AK-47s, assault weapons, multiple ones. Well, he's 10. He's not allowed to buy multiple assault weapons. Surely, law enforcement, again, taking his text very seriously, would charge him with illegal purchase of a gun. So now we move to the third text, in which he posts that he's looking forward to a party at school. They charge him with that. They tie together two texts they know are ridiculous.
Paulson argues the law is already on Daniel's side.
The Supreme Court has made clear that it has to be very specific, very definite, and imminent. And there's nothing specific in terms of a threat from this young man.
The Supreme Court is expected to share its opinion by the end of June. Regardless of the decision, our legal experts say the case brings attention to the fact that mens rea, which means of guilty mind, is a fundamental principle of U.S. law. That's something the prosecution in Daniel's case will have to demonstrate, and Judge Carolyn Swift will have to rule on at his trial in July. I will be there to show you what happens. Celine MacArthur, Wink News.